Florida Department of State Division of Corporation, Florida Not-for-Profit Corporations Act. 6. Information provided with the record of transcript of the transmission testimony obtained by the Department of Legal Affairs pursuant to this section confidential except for the provisions of Statute 119.071 and Statute 24A, the Art 1 of the State of the Constitution investigates and shall be considered active while the investigation being conducted with reasonable good faith and belief that may believe the filing of the administration of civil or criminal penalty proceedings. Investigation does not cease to be active as such along the department is proceeded with the responsible dispatch. There is good faith and belief that action may be initiated by the department or administration law enforcement agency except for the act of criminal intelligence and criminal investigation information as defined in Statute 119.0111, information which the disclosure will reveal the trade secret defined in Statute 688.002 would jeopardize the safety of an individual. All information record of the transcript may become available to the public when the investigation completed ceased to be active. The department should not disclose confidential information records, transcripts, testimonies, except pursuant to the authorization of the Attorney General in the following circumstances: law enforcement agencies participation conducting civil investigation under Chapter 895, participating in conducting criminal investigation, Corp for the filing of the participation in or conducting judicial proceeding instituted pursuant to Section Chapter 895, and Corp for the filing, participating in or conducting judicial proceeding to enforce an order or judgment entered pursuant to Section Chapter 895. In court for the criminal proceeding, any personal law enforcement agency receiving the information record transcript of the testimony that has been confidential by the subsection shall maintain the confidentiality of such material shall does not disclose such information record of the transcript testimony except for the provided with the hearing. Any person that willfully discuss the information record of the transcript of the testimony has been confidential by this subsection as is provided within the chapter. Subsection commits misdemeanor for the first degree punishable with the provided with the Statute 775.082, Statute 775.083, information recorded in testimony pursuant to subsection 2 offered in the evidence of the judicial proceeding in the court within the district and seal the portion of the record with further policies and confidential set forth in the subsection. 7. This section is supplemental and shall not be construed in the precluded limited of the scope of the evidence gathering other permissible to discover pursuant to other subpoena to discover the method of the authorized law of the rules or procedure. It is unlawful to any person with respect to any record with the testimony perceived with the pursuant to subpoena issued the Department of Legal Affairs under subsection 2 to only willfully, falsely conceal and cover up the material facts by a trick or scheme, the device, make any false, fictitious, fraudulent statement, the representation, make any use of false writing, documentation, knowing the writing, documentation containing any false, fictitious, fraudulent statement, entry of the person who violates the subsection commits a felony of the third degree punishable, provided in Statute 775.082, 775.083, and 775.084. In absence of written agreement with the contrary, the registered agent is not liable for failure to give the notice to the recipient and subpoena under subsection 2 for the corporation, foreign corporation, alien business organization, appointment of the registered agent timely sends the written notice to receive the subpoena the first class mail of domestic international air postage, fees prepaid to the last address that has been designated in writing with the registered agent with appointing of the corporation, foreign corporation, or alien business organization. The designated registered agent and the registered officer required of the subsection 1 of the corporate foreign corporation or alien business organization that owns the property in the state of the mortgage of the real property with the state solely for the purposes of the chapter, notwithstanding Statute 488, 181, 617, 1502, 617, 1503, any other further relevant section of the Florida statutes such a designation may not be used to determine whether the corporation, foreign corporation, or alien business organization actually doing business in the state. 11. As used in the section in the terms alien business organization means any corporation, association, partnership, the trust, joint stock company, and other entity organized under the law of other than the law of the United States, any United States, the possession of any of the state of the United States. Any corporation, association, partnership, the trust, joint stock company, other entity, device of the 10% or more that which is owned with controlled directly, indirectly by the entity prescribed in subparagraph 1 of the foreign natural person. Financial institution. 1. A bank of the bank organization, saving association defined in Statute 22862. Insurance company, trust company, credit union, industrial savings bank, any which of the license regulated with the agency for the United States, any state of the United States, any person licensed of the provision in Chapter 494. Mortgage means that the mortgage of the real property situated within the state, with except for the mortgage owned by the financial institution. Real property means the real property situated with the state and any other interest in such a real property. Ultimate equitable owner means that the natural person who directly and indirectly owns the control of the ownership of the interests of that corporation, foreign corporation, alien business organization, regardless of whether such a natural person owns the control of the ownership of the interests of one or another natural owners, one or more proxies, powers of attorney, nominees, corporation, association, partnership, trust, joint stock, companies, other entities, devices, or any other combination thereof. 12. Alien business organization may withdraw registered agent designated by the delivering application for the certificate withdrawal to the Department of Filing while the application is set forth. The name of the alien business organization, the jurisdiction under the law with which is incorporated to organize. This is no longer required to maintain a registered agent in the state. 617-0504 Service process notice demand on a corporation. Process against the corporation may be served in accordance with Chapter 48 and Chapter 49. Any notice of the demand of the corporation made pursuant to the Act may be made with the chairman of the board, president, with the vice president, secretary, treasurer, registered agent with the corporation, registered officer for the corporation in the state, any address in the state with the fact as principal officer of the corporation in the state. 3. The section does not provide for the only means of the necessarily required means for the serving the notice and demanding on the corporation. 617-0505 Distribution exemptions. Exempted as authorized in Statute 617-1302, a corporation may not make any distribution to the member, the director's officer, the mutual beneficial corporation, private club established for the social pleasure with a recreational purpose is organized as a corporation for which the equity interests are held with the members may subject to the Statute 617-1302 purpose for the equity membership with interest any of the member but the mayment of such interest in the distribution for the purpose of this section. The corporation may compensation in any of the reasonable amount of the member, the director, of the officer, serve the render may confer benefits and upon members of conformity with the purposes upon dissolution, final liquidation may make the distribution member that is permitted with the chapter. It's expressly permitted the articles in corporation may distribution upon partial liquidation of the members as permitted in the section. Each of the such payment benefit distribution does not constitute the dividend or distribution of income profit from purposes of this section. Corporation for the utility exempt with the regulation under the statute 367-022-7 with the article for the incorporation stated exempt with the taxation under the statute 501c12 of the Internal Revenue Code. Make a refund to the prime member of the prior dissolution, liquidation, the managing of the board of the deemed necessary to establish preserve the tax exemption status. Any such refund if it does not constitute a dividend distribution income profit for the purpose of this section. A corporation that regulated with the chapter 718, 719, 720, 721, 723, the corporation membership and such for the corporation requested pursuant to the document recorded with the county with the property records make a refund for the member to give it the credit for the member of the distribution insurance proceeding to its member the reversing payment settlements to the members without violating this section. 617-0601 members generally. Corporation may have only one more of the class, but the members may have no members if the corporation may have no members. If the corporation has one or more class, but the members of the designation such of the class or class of the qualification rights of the members of each of the class live in any quorum of the voting requirement of the meeting of the activities of the members. The notice of the requirements sufficient to provide the notice of the meeting of the activities of the members must be set forth the articles of incorporation in the bylaws. The articles of corporation or the bylaws any corporation non-profit maintained with the chapter affiliated with the grant representative of such chapter affiliated with the right to vote in conjunction with the board of directors of the corporation, notwithstanding the applicable quorum of the voting requirement of the chapter if the corporation is registered with the department pursuant to statute 496, 401, 490 through 496, 424 solicitation contributions. The subsection does not apply with the condominium association organized under the chapter 718. The corporation may issue the certificate membership of the stock certificates issued under the former statute 617-011-2 for statute 890 1989 constitutes certificates of membership purpose for the section. Corporation may have no voting other than rights except the provided with the articles and corporation bylaws. However, the members standing for the corporation on July 1st, 1981 shall continue to have the same voting other rights as before such a date until changed with the amendment of the articles and corporation bylaws. Corporation shall make the membership of the book in alphabetical order. The name and the address of each of the members of the corporation shall also keep the records in accordance with the statute 617-1601. Resignation, expulsion, suspension, termination of the membership pursuant to 617-0606 or 617-0607 shall record with the membership of the book, unless otherwise provided with the articles and corporation bylaws. All rights for the privileges of member chief of the termination of the membership. Subsection 1, 2, 3, and 4 do not apply with the corporation that association defined in statute 72301. When articles in corporation expressly limited membership of the corporation property, the owner of specific members measurable geographical boundary with the corporation has been form with the benefit of all the property of the owners. No such property owner shall be denied with the membership, provided with all the property owners once submitted with the membership to comply with the terms and conditions of the membership, any bylaw, the rules of the regulations contrary to be deemed void, any of the person excluded from the membership of such bylaws, rules, and other regulations are deemed member of the full rights, include the right and the majority otherwise provided with the articles of incorporation to call for the meeting of the membership. 617-0604, limited liability member. The member of the corporation is not in such a personal liable for any of the acts of debit liability obligation of the corporation. The member may become liable to the corporation for dues and assessment and fees provided by law. 617-0605, transfer of membership interest. The membership of the corporation transfer the membership of any right with the rising for the membership except with otherwise allowed in this section set forth in the articles of incorporation by law with the mutual benefit of the corporation. A member of the mutual benefit of the corporation must transfer the membership or any of the rising above rising for the membership. The transfers has been provided with one or more of the members of the mutual benefit of the corporation. The restrictions of such rights are not binding with respect to the member of the hold with the membership issued before the adoption restriction unless the restriction is approved by the members and effective with the member. 617-0606, resignation of members. Acceptance may be provided with the articles of incorporation by law of the corporation. Member of the mutual benefit of the corporation may transfer the membership with the rising with the right from the membership. The resignation of the member does not relieve the member of any of the obligation of the member that may have the corporation as a result of the obligation incurred with the comments made before the resignation. 617-0607, termination, expulsion, suspension. Member of the corporation may not be expelled or suspended, but the membership in the corporation may not be terminated or suspended except pursuant to the procedure with the fair, with reasonable, carried out in the good faith. A written notice given by mail must be delivered and certified with the mail, the first class mail to the last address for the member shown with the record of the corporation. In proceeding challenge with the expulsion, suspension, termination, including the proceeding with the defective notice, the alleged must be commenced within 1 year after the effective date of the expulsion, suspension, and termination. A member who has been expelled or suspended may be liable with the corporation for the dues, assigning of the fees as the result of the obligations incurred with the comments made before the expulsion and the suspension. 617-0608, purchase of the membership. The corporation may purchase any of the items of the membership and any right with the rising for the membership except provided with the statute 617-0505, subsection 2, the subject 16, statute 617-1302, with the mutual benefit that may be purchased for the membership of the member of the resigned with the membership of the terminated with the member of the pursuant to the conditions set forth in the articles and corporation bylaws. 617-0701, meeting the members generally failure to hold annual meetings, special meeting with the consent with the corporate action without meeting with waiver of the notice of the meeting. The frequency of all the meetings of the member, the time and the manner of notice of such meetings, the conduct with the adjournment with such meeting, the determination of the members entitled to the notice and or the vote, or to vote with such meeting, the number of the voting with the members that necessary to constitute the quorum shall determine in accordance with the articles and corporation bylaw. The place and time in all the meetings may be determined by the board of directors. Failure to hold an annual meeting does not cause forfeiture, given the cause of the dissolution of the corporation does not have such failure affected otherwise valid corporate acts, except with the provided in the statute 617-1430, with the case of a deadlock among the directors and members, except for provided with the articles and corporation bylaw. A special meeting with the members may be called with the president, the chair of the board of directors, the officers, person that provided with the articles and corporation of the bylaws. Either holder of at least 5% of the voting power for the corporation with one or more written demand for the meeting with describe the purpose of which meeting is to be held and signed, dated, delivered to the corporate officer, or a person who is demand with the special meeting pursuant to paragraph E of the notice of the special meeting is not given within 30 days of the receipt of demand. The persons may sign with the meeting and sign the demand with the set time with the place for the meeting with the give the notice under the subsection 4, unless otherwise provided, the articles of incorporation action required with the permitted with this chapter to have been taken annual with a special meeting without members may be taken without meeting without prior notice without the vote of the action and taken with the members entitled to vote on such action have not less than the minimum number of the votes necessary to authorize such action at a minimum with all the members entitled to vote on that such action presented voted. To be effective with the action, the evidence may be the warm written consent with describing the action taken, dated, and signed with approving the member that have been a requisite number of the votes entitled to the vote of such action delivered to the corporation principal of the state and its principal place for the business of the corporate secretary and other officer agent of the corporation have the custody of the books in which proceed with the meeting with the members are recorded with the written consent to take the corporate action referred to and the consent is non-effective unless the consent is member having the requisite number of the votes necessary to authorize the action within 90 days of the day of the earliest date with the consent with the delivered manner required of this section. Any written consent revoked prior to the day of the corporation received the required the number of the consent authorized proposed the action revocation of the non-effective unless it's written until the receipt of the corporation in its principal office in the state and the principal of the place of the business received with the corporate secretary or other officers, agent with the corporation, having the custody of the book in which proceedings immediately the members are recorded. Within 30 days of obtaining the authorization, written notice must be given to those members entitled to vote with the action who have not consented with writing. The notice must be summarized with the material feature of the authorized action. Consent with the signed by the under this section with the effect of the meeting vote may be described in such an any document if the action with the members considered for the such would be required with the vote of the articles and certified under the action with the section of the chapter in this section has been voted with the members at the meeting of the article of the certificate filed under such much as state written consent will be given in the accordance with the section. Whenever their action is taken pursuant to the section, written consent with the members consenting with such action, written reports, inspectors appointed with the tablet such as consent may be filled with the minutes of the members of the proceeding. 5A. Notice of the meetings of the members need not to be given to any member who has signed for the waiver of the notice in person and the proxy either before and after the meeting, unless required by the laws, neither the affairs of the transaction for the purpose of the meeting that needs to be specified in waiver. Attendance at the meeting either in person or proxy constitutes waiver notice of the waiver of any and all objections to the place of the meeting at the time of the meeting, the manner in which it has been called and conveyed, unless the members attend the meeting solely for the purpose of the stating at the beginning of the meeting. At the beginning of the meeting, any such for the objection for the transaction affairs. 6, subsection 1 and 3 do not apply to any corporation that associates and defined in Statute 72301, the corporation regulated with the Chapter 718, 719, 720, and 721, Chapter 723. The corporation will member the membership in such a corporation required with pursuant to the document recorded with the county property records. 617-0721 voting member. The members are entitled to vote except for the conferred with the articles of incorporation or bylaws. Members who are entitled to vote may vote with the person unless for the article of incorporation for the bylaws otherwise provided may vote with the proxy executed the writing by a member of his or her duly authorized attorney. In fact, the appointment of the proxy is not valid for after 11 months following the date of the execution unless otherwise provided with the proxy. The director of the office elected with the members' bylaws may be provided such the election may be conducted by mail. But corporation reject the vote, consent with the waiver of the proxy appointment with the secretary of their officers, and grant authorized with the tablet vote for the acting with the good faith of his reasonable basis with doubting with the validity of the signature on it with the signature authority to sign for the member. If authorized by the Board of Directors, subject to the guidelines procedure, the Board of Directors may adopt the members of the proxy holders not physically present with the meeting of the meetings with remote communication. Participate in meeting may deem the present in person vote at the meeting. The corporation implements the reasonable means to verify that each of the person deemed present with the authorized to vote may to be remote with the commotion communication as a member of the proxy holder. 2. The corporation implements reasonable measures to provide such a member of the proxy holder with reasonable opportunity to participate with the meeting. The vote on the members submitted to the members include the opportunity for the communication to read and hear the proceeding with the meeting, the substantial concurrent with the proceedings. And any member of the proxy holder votes take their action meeting with the remote communication recorded with the members participated meeting of the maintained with the corporation in accordance with the statute 617-1601. If any of the corporation, whether the profit and profit the name of the corporation or organized with the chair of the board and president of the vice president, secretary of the treasury, member of the corporation, any such officer cashier with the trust officer with the banking and the trust corporation holding such membership and like officer of the one corporation, whether they're profited or not for the profit of holding the membership of the domestic corporations of the deemed by the corporation, and whether the membership itself have authority with the vote of the behalf of the membership of the corporation to execute proxies right and waive the consent in relation to, but unless otherwise before the vote is taken with the waiver of consent that acted upon appears pursuant to the certified copy of the bylaws resolution of the board of the director executive committee of the members corporation, such as the authority does not exit or vested in some other officer or person. In absence such a certification, person executing any such proxies waive the consent with the presenting himself or herself at a meeting. One of such officers corporate members shall be, for the purpose of the section, conclusively deemed to be duly elected to do qualified action as such an officer, and to be fully authorized in case of the conflicting representative with the corporate member that shall be represented with a senior officer in order to state with the subsection. Alright, the articles of incorporation by the law is provided with all the elections of the directors. Every member then entitled to the vote to the right of the communicate his or her votes with the give the one candidate with a member of the number of the votes equal to the number of votes he or she could give them to, if one of the directors were being elected, with the multiply of the number of the directors elected with the distributed such votes in the same principle among any of the number of the candidates. A corporation may have the community of the voting unless such voting is expressly authorized by the articles of incorporation. If the corporation has no members, its members do not have the right. If the corporation has no members, its members do not have the right to vote, and the directors shall have no sole voting power. Subsection 1, 5, and 6 do not apply with the corporation that is an associate with the definition 720.301 of the corporation regulated within Chapter 718 and Sub 19. 617.0725, a quorum. In amendment to the Articles of Incorporation by law of the change to delete and the greater or less of the quorum, voting requirements must meet with the same quorum. Voting requirements must be adopted with the same vote. The voting group is required to take action under the quorum. The voting requirements then in effect for the proposed adopted, whichever is greater. 617.07401, member of the directive of the actions. The person may commence the proceeding in the right of the domestic foreign corporation unless the person the member of the corporation when the transaction complained with the order occurred, but then if the person became the member of the temporarily transferred the operation law of the one who was the member at the time of the complaint proceeding throughout with the right of the domestic foreign corporation must be varied on alleged if the particular demand with the made obtained the action of the board of directors of the demand with refused ignored by the board of directors for at least 90 days after the day of the first demand unless before the execution of the 90 days the person will be notified in writing with the corporation rejected the demand unless irreparable injury with the corporation would result in the waiting of the expiration of the 90-day period. If the corporation commences with the investigation of the changes charges made with the demand and the complaint with the court may be stay and proceed with the investigation is completed. Through the court dismisses the directive of proceeding within one motion for the corporation finds one of the groups specified in paragraph A through C with the reasonable has good faith determination for conducting reasonable investigation upon the conclusion are based with the maintenance of the right of the suit, but is not in the best interest of the corporation. The corporation has the burden of proving independence with good faith. The group making the determination responsible for the investigation. The determination shall be made. Majority of the independent directors present at the meeting of the board directive of the independent director of the constitute a quorum major vote of the committee with consisting of the two or more independent directors appointed by majority of the vote. Independent directors present at the meeting with the board of directors whether or not such independent directors constitute a quorum. Panel of one or more of the independent persons appointed by the court upon the motion by the corporation proceeding commenced under the section may be discontinued settled without the approval of the court if the court determines the proposed discontinuance settlement substantially affected the interest in the members of the corporation class series and voting of the group. Members of the court shall direct the notice given the minute members of the effective of the court determine which party for the parties of the proceeding shall be bear with the expense for the given notice. Upon termination of the proceeding, the court may require the plaintiff to pay with the defendant reasonable expense, including reasonable attorney fees, including the defending with the proceeding if finds if the proceeding was commenced without reasonable cause. The court may award the reasonable expense for the maintaining proceeding, including responsible attorney fees, the successful plan of the person commenced with the proceeding of the receipt with any with the leap of the judgment compromise. The settlement may require the person to account with the remainder of any with the receipt of the corporation. However, the subsection does not apply to the relief to render with the benefit of the injured members. Only is limited to the recovery, loss, and damage to injured members. 617.081, 0801, 617.0801. Due to the board of directors, all the corporate members must be exercised under the authority of the corporation managed under the direction of the board of directors, subject to any of the limitations set forth in the articles of corporation. 617.80802. Qualification director. Directors must natural person with 18 years of age must not be the directors must be a natural person who is 18 years of age but older but not limit but need not to be resident of the state of the member of the corporation unless the articles of incorporation bylaws so require. For a corporation organized according with the provisions of the statute set 501c for their internal revenue code in 1986, the member for a corporation regulated with the chapter 718, 719, 720, 721, 723, corporation which membership in such a corporation is acquired pursuant to the document recorded by the county property record that one directed by the 15 year of age of older permitted by the articles of incorporation bylaws. Resolution of the board directed the articles of incorporation bylaws may prescribe additional qualification for the directors. In the event of the eligibility to serve the member of the board, director of the condominium association, cooperative association, homeowners association, mobile homes owners association, restricted members in such an association members are prudent to the membership, ownership of the unit, parcel, mobile home grantor, or the truster. Trust of described in statute 733-7073, with the beneficiary defined in the form of 737-3034B, with the trust who owns the unit, parcel, mobile home shall be deemed the member of the association eligible to serve direct condominium association, cooperative association, homeowners association, mobile homeowners association, provided the city professional beneficiary occupies the unit and parcel mobile home. 617.0803. Normal number of the director. The board of the director must consider the three or more individuals the number that's specified in the fixed in accordance with the articles of corporation of the bylaw. The number of the directors may increase and decrease from time to time, but amended into or manner of the provided articles and corporation of the bylaws. Corporation must never have fewer than 3 directors. The director shall be elected upon appointed in the manner of the term that's provided by the Articles and Corporation bylaws. History of Statute 40, Chapter 90 through 179, 617-0806. Staggered term of the director of the Articles and Corporation bylaws provided the director has divided into classes. Each director shall hold the office of the term in which he or she is elected and appointed until his or her successor has been elected and appointed and qualified until his or her earlier resignation, removal, office, or death. 617-0807. Resignation of the director. The director may resign at any time, delivering written oath to the board of directors and chair of the chair of the corporation. Resignation with effective with the notice delivered unless the notice specified later. Effective with the date of the resignation made immediately. Effective with the later of the date of the board of directors may fill with the pending of the vacancy before the effective date of the board of directors, provided the successor does not take office until the effective date. 617-0808. Removal of the director. Subject to subsection 2, the director is removed from the other pursuit and procedure provided with the Articles and Corporation of the bylaws, which shall provide with the following. If they do not so, they should be deemed to include the following. Any member of the board of directors may be removed from office with or without cause, except provided with paragraph 1 with the majority of all the votes of the directors. If the director was elected with appointed by the directors, majority of all the votes of members. If the director was elected with appointed with the members, the director is elected with the class and chapter of the organizational unit of the region other than the geographical grouping. The director may be removed only by the members of the class, chapter, unit, or grouping. However, the director may be removed only by the number of the votes that you can cast to remove the director would be sufficient to elect the director. The meeting to elect the director, except the provided in paragraph 2 and 3. Alright, 2. The cumulative voting of the authorized director must not be removed with the number of the votes sufficient at least to elect the director under the cumulative voting of the voting against the removal of the director. 3. At the beginning of the term of the director, the Articles and Corporation bylaws provide that the director may be removed by missing a specified number of board meetings. The board may remove the director failing to attend the specified number of the meetings. The director may remove only the majority of the director of the then of officers' votes them removed. The notice of the meeting to recall the member of the board of directors shall state the specific directors sought to be removed. D. The proposed removal of the director meeting shall require a separate vote with each of the director who is removed and sought. Removal is sought. When the removal is sought by the written consent, separate consent is requested for each of the director to be removed. If the removal effective of the meeting and any of the vacancy created shall be filled with the members of the director eligible to vote, with removal any of the director who is removed at the board is not eligible to stand re-election until the next annual meeting in which the directors are elected. Any director removed from the office shall term over the board of directors within 72 hours of all records of the corporation in his or her possession. H. If the director is removed, he does not relinquish his or her office turn over the records required for the subsection circuit court in the country county with the corporation principal office is located summarily under the director of the relinquish his or her office turn over the corporate records of this application any member. A director elected without appointed of the board may be removed with the cause of the 2/3 of the director and then office of such grade of the member that is set forth in the Articles and Corporation bylaws. Any director of the corporation described in Statute 501C for the internal of the code may be removed from the office pursuant to the procedure provided by the Articles and Corporation with the bylaws of the corporation provides in the Articles and Corporation bylaws that subject to provisions subsection 1. 3. The section does not apply with any of the corporation that is an association defined in Statute 72301 and a corporation regulated under Chapter 718, Chapter 719. 617-0809. Board vacancy is provided with the statute 617-0808. If any of the vacancy occurring, the board directors may fill the affirmative vote of the majority of the remaining directors, even though the remaining directors constitute left at the quorum by the sole remaining director of the vacancy is not so filled with no director remains the member of the application with the aim of the person of the circuit court of the county were registered over the corporation located. Whenever the vacancy occurred with respect to the director elected with the class of the chapter unit of the group, the vacancy may be filled with the only members that class, chapter, the unit of the group. The majority of the directors in the office are elected with such class and chapter unit of the group. The term of the director elected and appointed to fill vacancies expires at the next annual meeting when the director is elected. Any directorship by reason of the increase of the number of the directors may be filled with the board of directors by only one term, with the continuing until the next election. Directors members of the corporation has no member that no more members have the right of thereon for such office that they provided with the articles of the corporation or the bylaw. If the vacancy will occur with the specific later by the reason of resignation of effective later with the date of the statute 617-0807, otherwise be filled with the vacancy occur. However, the new director may not take it until the vacancy occurs. 617 is 08101. Compensation of the directors. Unless articles of incorporation of the bylaw provides otherwise, board directors may fix the compensation of the directors. 617-0820 meetings. The board of directors may regular special meetings in or out of the state. The majority of directors present whether the quorum exists for the major adjourning meeting of the board of directors any other time, place for the bylaws. Otherwise, provided notice that any of the adjourning meetings shall be given to the directors who are not present at the time of the adjournment, unless for the time and the place for the adjournment meeting were announced at the time of the adjournment of the other directors. 3. The meeting of the board of directors may be called with the chair of the board, but the president, unless otherwise provided by the articles of incorporation and bylaws, unless the articles of incorporation and bylaws provide otherwise left. The board of directors may permit all the directors and participate in regular special meetings with the meeting with the use for the meeting with the meetings communication with all the directors' participation. May simultaneously hear each other during the meeting of the director participation meeting of the mismeaning deems the present the person at the meeting. 617-0821 act for the director without meeting. Lift the articles and corporation bylaws otherwise provide action required for the permitted to act to be taken with the board of the directors meeting. The committee may be taken without meeting of the action with taken all the members of the board of the committee. This action may be the evidence of one or more written consent with describing the action taken and signed by each of the director and committee member. Action taken under the section effective with the last director signed with the consent unless this consent specified the directive effective date. Consent signed under this section has the effect of the meeting vote may be described as signed in any document. Alright, 617-0822 notice of the meetings. Unless articles with the corporation bylaws otherwise regular meetings of the board of directors may be held without notice of the date and time and place and purpose of meeting. Unless articles of incorporation of the bylaws provide longer or shorter period for the special meeting of the board of directors must be preceded by at least 2 days of the notice of the date and time and the place for the meeting. The notice need not to be described purpose for the special meeting unless required for the articles of incorporation of the bylaws. 617-0823 waiver of the notice. Notice of the meeting of the board of directors need not to be given in any direction if you sign with the waiver of the notice either before or after the meeting. The attendance of the director at the meeting shall constitute the waiver of the notice of the special meeting. The waiver of any of all the objections placed in the meeting, the time of the meeting, the planner of which has been called for the convened, except with the director of the states at the beginning of the beginning of promptly upon approval of at the meeting. Any object transaction affairs because of the meeting and not lawfully called or convened. Conveyed. 617-0824 quorum of the voting. Using articles of incorporation of the bylaws, a different number of the quorum of the board of directors consist of the majority of the number of the directors prescribed in the articles of incorporation bylaws. Director younger than 18 years of age may be counted towards that quorum. Articles of incorporation may authorize the quorum of the board of directors to consist of less than the majority, no fewer than 1/3 of the prescribed number of the directors determined under the articles of incorporation or bylaws. If the quorum to present the vote is taken the affirmative vote with the majority of the directors present and act with the board of directors, unless the articles of incorporation bylaws require the voice of the greater number of the directors. Board director of the corporation presents a committee meeting of the board of directors of the or committee of the board of directors, but the corporate action is taken is deemed to have ascended to the action taken unless the director objects to the beginning with the meeting of the prompt upon his or her arrival to hold the meeting and transaction specified affairs with the meeting. The director votes against abstaining them from the action taken. 617-825 on committees. This articles of incorporation of the bylaws otherwise provided with the board of directors by the resolution adopted the majority of the full board of the directors may designate among the members of the executive committee one or more of the other committees, each of which for the extent of the provided with such a resolution articles of incorporation bylaws of the corporation shall have the name that exercises the authority of the board of directors, except no such committee shall have the authority to approve recommended the members' action proposal required by this action to be approved by the members. Fill a vacancy for the board of the directors, any for the committee thereof. The sheet adopt the amendment of the repealed bylaws. 2. Unless the articles of incorporation of the other bylaws provided otherwise, the statute 617-0821, 617-0822, 670-0823, and 678-24 cover the meetings. Notice of the waiver note for the quorum voting with the requirement the board of directors apply with the committee thereof members as well. If the committee must have the 2 or more members that serve at the pleasure of the board of the directors. The board of this resolution adopted in accordance with subsection 1 may designate one of the board of directors alternate members of any such committee may have act in place with instead of the absent member of the members of any meeting of such a committee. Neither designation of any of the committee delegation thereto other authority nor action committee pursuant to such authority had alone constitute compliance with any of the number of the board of directors, not a member of the committee with the question whether his or her responsible to act in good faith in a manner he or she reasonably believes to be in the best interest of the corporation, which of the care of this ordinarily prudent person is likely position would use under similar circumstances. 617-0830 General Stand for the Director. Director shall be discharged as his or her duties as the Director, including his or her duties as a member of the committee. A good faith and within the care of the ordinary prudent person is a likely position would exercise under similar circumstances in a manner he or she reasonably believes to be in the best interest of the corporation. In discharging his or her duties, the director may rely on the information, opinions, reports, statements, including financial statements, other financial data, if prepared on presented by one or more officers, employees of the corporation who directly reasonably believe that reliable and competent into the manners presented. Legal counsel, public accountants, or other persons that are matters the director are responsible to believe that within the person professional with the expertise, competency, company of the board of the directors, if he or she is a member, if the director reasonably believe the committee with the permits merits confidence. The director is not acting in good faith if he or she acknowledges the concern of the matter of the question that makes the reliance otherwise permitted by the subsection 2 unwarranted. 4. Director is not liable to if any of the action taken in the director or any of the failure to take any action if he or she has performed the duties his or her office is in compliance with this section. Alright, 617-0830-831, identification and liability of the officers and directors, employees, and agents, except provided in statute 617-0834 and 617-0831, 607-0850, applied with the corporation organized with the Act of Rural Air Electrical Cooperative organized under Chapter 425 of the reference of the director in those sections, including the director managed with the trustee corporation organized under the Act of the Rural Electric Cooperative organized under the Chapter 425. However, the term director is included with the statute 607-0831, 607-80850. Does not include a director appointed with the developer of the board of the directors condominium associates under the Chapter 718, the cooperative association under the Chapter 719 homeowner association defined in statute 72301, the timeshare managing the entity under Chapter 721, a reference to the shareholder in such section include the members of the corporation organized under this act, a member of the Rural Electrical Cooperative organized under Chapter 425. 617-0832, the director or conflicts of interest. No contract or other transaction between the corporation and one or more of the directors, any of the other corporation, firm, and association, any with one or more of the directors or director for the officers or financial interests, it shall be either voided will be covered with such relationship with interest because the director and the directors are president of the meeting of the board of directors of the committee, but therefore the authorized, approved, ratified such a contract or transaction because of his or her vote that votes for the account with such a purpose. The fact of such a relationship with the interest is closed now with the board of the directors committee with the authorized, approved, the ratified the contract transaction by the vote of the consent sufficient for the purpose without counting the votes of the consent of the interested directors. The fact of the relation for the interest is closed now that the members are entitled to vote with such a contract transaction. If any, they will authorize, approve, ratify, and vote when wherein the consent for the contracting transaction is fair and reasonable as to the corporation at the time that is authorized by the board and committee with the members. For the purpose of paragraph 1A, the only conflict of the interest transaction is authorized, approved, and ratified, receive the affirmative vote and majority of the directors on the board of the directors on the committees who have no relationship to interest of the transaction described in subsection 1. The transaction may be not authorized, approved, or ratified under the section by a single director if the majority of the directors who have no relationship or interest in the transaction vote to authorize and approve of the ratifying the transaction. Quorum is present for the purpose of the taking action under this section. The presence of the vote cast in the director of having the relationship interest in the transaction does not affect the validity of any action taken under the paragraph 1A of the transaction authorized, approved, and ratified in subsection 1, but such of the present vote of such the director may be counted for the purpose of determining whether the transaction is approved under the section of the chapter. For purposes of paragraph 1B, with the conflicting interest of the transaction authorized, approved, but ratified, but received the vote of the majority in the interest of the member entitled to the vote under this subsection, the director who has the relationship of the interest of the transaction is described in this subsection 1 may not vote to determine whether they authorize or approve or ratify the conflict of the interest transaction in paragraph 1B, but however the vote of the director is counted in determining whether the transaction approved under the section of the chapter, the majority of the interest of the member is entitled to vote on the transaction under the subsection constitute with the quorum for the purpose of taking action on the subsection. As used in this subsection, the term majority in the interest, and refers to the majority of the voting shares other than voting units allotted to the members. Alright, 617-0833, loan to the directors and officers. Loans other than through the purchase of the bond, debenture of the similar obligation for the type of the customary solid of the public offering through the ordinary deposit of the fund, but the bank may not be made with the corporation, the director of the officers, to any with the corporation, firm, association, or other entity with which with one or more of the directors, officers, director of officers hold the substantial financial interest, except as the loan or one of the corporation was exempt with the federal income tax order of the statute 501c3 with the Internal Revenue Code 1886 amendment of the incorporation which was exempt with the federal income tax under Statute 501c3 with the Internal Revenue Code of 1986, with the amendment of the loan made violation of the section of the violation of the duty of the corporation with the directors or officers authorizing or participating in it, but the obligation of the borrower with respect to the loan is not affected. 617-0834, officer and director is certain with the corporation associated with a nonprofit immunity civil liability. An officer or director of the nonprofit organization recognized under Statute 501c3 with the Statute 501c4 and 501c6 Internal Revenue Code of 1986 demanded with the agricultural and horticultural organization recognized under Statute 501c5 of the Internal Revenue Code of 1986 demanded that it is not personally liable for monetary damages to any person within any state for any statement, vote, or decision failure to take any action regarding organizational management or policy by any officer or director unless the officer or director breached and failed to perform all his or her duties as an officer and director, and the officer or director of the breach of the failure to perform his or her duties constitute the violation of the criminal law unless the officer or director has reasonably cause to believe that his or her conduct was lawful and had no reasonable cause to believe his or her conduct was unlawful through judgment other than final adjunction against an officer or director in any of the criminal proceedings for the violation of the criminal law. It stops the officer or the director for the contesting of the fact that his or her breach of the failure to perform the constitute the violation of the criminal law, but does not stop the officer or the director from establishing that he or she had reasonable cause to believe that his or her conduct was lawful and no reasonable cause to believe that his or her conduct was unlawful. 2. Any transcription with the officer or director derived with improper personal benefit directly and indirectly, recklessness of the act of the commission that was committed with bad faith and malicious purpose, or a manner exhibiting wanton, willful disregard of the human rights, safety, and property. For the purpose of this section, the term recklessness means the acting without mission with the act of the conscious disregard of this risk, known so obvious that it should have been known to the officer and director, known the officer and director so obvious that they should have been known to be great as make it highly probable for the harm would follow with such action. A mission director means a person who serves as the director, trustee, member of the governing board of the organization. Officer means a person who serves as an officer without compensation except the reimbursement of the actual expenses incurred to be incurred. Alright, 617-0835, prohibited activities by private foundations. Use the section of reference unless otherwise indicated to refer to the Internal Revenue Code of 1986 as amended in Title 20 of the United States Code, including the corresponding provisions of any subsequent federal tax law. Corporation during the period of its private foundation as defined in Statute 509A may not engage in any act of self-dealing as defined in the Statute 4941D, which would give it its right to any liability for tax imposed by 4941A. Retain any excess building holdings as defined in Statute 4943C, which would give the rise to any liability of tax imposed by law of Statute 4943A. Any investments which would be jeopardized the carrying out any of the exempt purposes which mean with the Statute 49444 to give the rise to any liability tax imposed in Statute 4944A. Make any taxable expenditures defined in Statute 49445D, which would give the rise to any liability of tax imposed in Statute 4945A. Each corporation during the period of its private foundation defined in Statute 509 shall distribute the purposes specified in the article of the incorporation organization for each taxable year the amounts at least sufficient to avoid liability for the tax imposed by Statute 4942A. The provisions of subsection 2 and 3 do not apply to any of the corporations to the extent that the corporation completely jurisdiction determines that such the application will be contrary to the terms of the articles of incorporation, organization, or the other instrument of governing such corporation for the governing and administrative of the charitable funds held in it. The same not properly be changed to conform to such subsections. 5. The section shall not impair the rights of the power of the courts to the Department of Legal Affairs with respect to any of the corporation. 617-0840, required officers. A corporation shall have the officers described in articles of incorporation by the laws, but it shall be elected for the appointment at such time as terms provided by the article of incorporation by laws. In the absence of any of such provision, all officers shall be elected and appointed with the board of directors annually. A duly appointed officer may appoint one or more officers, assistant officers, and authorized by law of the board of directors or by the board of directors. Bylaws of the board of directors shall delegate one of the officers responsible for preparing the minutes of the directors and members of their meetings and the authentication records of the corporation. The same individual may simultaneously hold more than one office in one corporation. 617-0841. Duty of the officer. Each of the officer's authority shall perform the duties set forth and by the law if consistent with the board of the law by law of the duties prescribed by the board of the director's direction, and any of the officers authorized by the bylaw of the board of directors to prescribe the duties of the other officers. Alright, resignation and removal of the officer. Any officer may be resigned at any time, delivering a notice to the corporation. Resignation effectiveness for the notice delivered unless the notice specified a later effective date. If the resignation was made after effective at a later date, the corporation accepts the future effective date, and then the board of directors may fill the pending vacancy before the effective date. If the board of directors provides a successor does not take office until the effective date of the pending of the vacancy, the board of directors may remove any of the officers at any time without cause. Any of the officers, assistant officers, if appointed with another officer, may likewise be removed by such officers. 617-0831-843. Contractor right of the office. Contract right of the officers. Appointment officers does not have itself create the contract rights. Officers removal does not affect the officer's contract rights, if any, with the corporation. Officer resignation does not affect the corporation contract rights, if any, with an officer. 617-0901 reincorporation. Any corporation with a chapter approved the circuit judge under the forming of the Chapter 617 Florida State Statute 1989, charge granted by the legislative of the state and prior to September 1st, 1959, effective date of Chapter 59 through 4020. So the law of the Florida may reincorporate under the act of the filing of the Department of the State with a copy of the charter of all amendments thereto, and court certified with the clerk of the circuit court of the county wherein recorded as the charge of the amendment granted by the circuit of the judge and the Department of the State as to legislative charter, together with a certificate contained with the provision required with the original articles of incorporation by the statute 617-0202, the accepting of the provision of this act. Certificate reincorporation must be executed in accordance with the statute 617-1201 and must show the issuance of duly authorized by the meeting of the members of the regularly called if there is no member entitled to the vote, and reincorporation by the meeting of the board of directors upon filing a certificate of reincorporation in accordance with the statute 617-01201. Corporation shall be deemed to be incorporated by the act of the certificate shall consist of its articles of incorporation. Corporation shall have entitled to be possessed with all the privileges, franchise with the power of the original incorporated under this act, and all properties, rights, and privileges belonging with the corporation prior to the reincorporation, which is required to be gift, grant, conveyancing, assignment, and otherwise are hereby ratified, approved, and confirmed as assured the incorporation like effect to all intents and purposes that they have been originally acquired pursuant to the incorporation under this act. However, any incorporation, reincorporation under this act shall be subject to all the contract duties and the obligation of retesting resting upon the cooperation prior to the reincorporation, which the corporation shall then be any way liable. Alright, 617-1001, authority to amend articles of incorporation.